kindly turn your cell phones off and find your seats, we'll begin shortly. Thank you. Thank you very much. Can everyone hear me okay? Everyone can hear me? Okay. Welcome to the American Islamic College Lecture Series program. Tonight we have with us Volkan Stodolsky, who will be speaking on a new historical model and periodization for the perception of the Sunnah of the Prophet and his companions. He has received his undergraduate education at Bates College, graduating Summa Cum Laude with honors in history. He also completed his master's in classical and medieval Islamic history at Oxford, and at the University of Chicago, he has studied in the Department of Near Eastern Languages and Civilizations, where his Ph.D. dissertation was recently accepted with honors. In 2008, he went to Syria as a Fulbright fellow to conduct research concerning the Hanafi school of Islamic law. Volkan had the opportunity to study classical Islamic texts with renowned experts in Arab, Turkish, and Indian ulama. Volkan's research interests include Islamic law and legal history, historiography, the instrumental Islamic sciences, syntax, semantics, logic, and rhetoric, Hadith and its methodology, Islamic theology, especially the Maturidi school, and Sufism. Please give a warm welcome to Volkan Stodolsky.
Hello. Assalamu alaikum. Alhamdulillahi wa kafa wa salamun ala ibadihi allazina istafa. I would like to begin by thanking Dr. Ali Yurtsever and the American Islamic College for their invitation and hospitality. Thank you very much. Tonight in this presentation, I would like to share with you the results of my dissertation. Since the dissertation deals with more than 500 years of Islamic legal history, and I have only half an hour, the time will only permit me to briefly introduce the historical problem, to explain the historical model I have developed as a response, and to give a brief summary of some of the significant legal developments. And I hope to be able to answer more detailed questions as best as I can in the question and answer session. The historical problem on which I have focused is the following. When we look at the earliest works of Islamic law and collections of Hadith from the 2nd century, that is to say the 8th century of the Common Era, it is apparent that the statements of the companions of the Prophet, together with statements of the Prophet and the Quran, form the primary sources of Islamic law. Yet in time, some of the most distinguished jurists from each one of the 4 extant Sunni legal schools would come to reject the legal authority of companion statements in part or in whole. So the historical problem is, how is it that a source that was once so relied upon and cherished come to be rejected by some jurists? This is related to a broader and more famous problem, which is the changing definition of the word Sunnah. Again, if we look at the Quran and the earliest sources from the 2nd century, it is evident that Sunnah simply means a repeated course of conduct, whether that conduct is good or bad. Yet in time, according to most jurists and legal methodologists, the word Sunnah would refer exclusively to the statements, actions, and the tacit consent of the Prophet. So how did this change take place? The two problems are very much interrelated. One of the most influential answers to the latter question in Western scholarship has been that of Joseph Schacht in the Origins of Mohammedan Jurisprudence. And even though that work was written more than 50 years ago, it has remained influential ever since. Schacht claimed that in the first Islamic century, the 7th century of the Common Era, the statements of the companions or the statements of the Prophet were not the real sources of Islamic law at all. Rather, Shah argued that the real source of Islamic law in the first century were the legal decisions of the Umayyad caliphs and their administrators and judges and governors in the various Muslim provinces. Shah argued that beginning with the second century, an opposition group emerged who wanted Islamic law not to be based on these old sources, that is to say, the Umayyad administrative practice and the anonymous traditions that grew up in the various Muslim cities, but rather they argued that Islamic law should be based on verifiable reports from identifiable authorities. Shah further argued that Shafi'i, one of the founders of the four extant Sunni legal schools, played a vital role in Islamic law by powerfully arguing that these identifiable reports should be the primary source of Islamic law, and convinced the jurists of the ancient schools who were reluctant to accept this new mode of thinking and wanted to continue relying on older sources. Over the years, a number of legal historians have found certain shortcomings in Shah's model. The fundamental flaw that became clear to me, as I read extensively in the literature from the second century, is that Shah envisaged this competition and conflict between two groups: the traditionalists who wanted to base Islamic law on these verifiable reports from identifiable authorities, and the jurists of the ancient schools who wanted to rely on the older sources of decisions of the caliphs and their administrators and the anonymous local legal traditions. So Shah saw a conflict between these two groups that was, with the help of Shafi, was won for this new opposition group which Shah called the traditionists. Well, what becomes clear from a detailed study of second century sources is that the position or the stance Shah attribute to the traditionists, the new group, is very much present in the legal methodology of what Shah called the ancient school of Kufa. So what we see in the earliest works of Abu Hanife's students, Abu Yusuf and Muhammad ibn Ḥassan al-Shaybani, is they argue precisely the point that Shah attributed to the traditions. That is to say, they reject local anonymous tradition as binding authority, and they reject the decisions of the caliphs, especially Umayyad caliphs, as possessing legal force. And so these are the jurists of what Shah called the ancient school of Kufa. On the other hand, the position Shah attributed to the jurists is very much present in the earliest works of the traditionists, the Hadith transmitters. In the second century, as opposed to the third century, Hadith transmitters were primarily archivists. That is to say, they wanted to collect everything from the past. And so it didn't matter whether these were Umayyads or scholars who opposed Umayyads. In the same Hadith collections, they collected reports from both groups. At the same time, whether the report was identifiable or whether it was anonymous was also not very significant for them in the second century. They simply wanted to collect everything they could from the past. So this included both identifiable reports and anonymous reports. It included reports from the Umayyads and their governments and their bureaucrats, and scholars who opposed them and even fought against them. So basically, the position Shah attributes to the ancient schools one can find among the traditionists, and the extant works from the traditionists, such as the Muwatta of Malik and the Musannef of Ibn Abi Shaybah and Abdurrazzaq as-San'ani and the Sunan of Sayyid ibn Mansur. And the position Shah attribute to the traditions one can find in the earliest Hanafi works before Shafi. The alternative model I have suggested is called the accumulation, stratification, and contraction elimination model of Islamic law. So what do these terms refer to? By accumulation, I mean the increase within the scope of a particular legal source. So if we take the companion statements as an example, accumulation will be due to various factors, such as the various statements one companion would make throughout his life, the various statements various companions would make, the parallel transmission of these statements, inevitable misattributions due to lapses in memory and other factors, and intentional fabrication. So as a result of these factors, we have the increase within the scope or within the content of a particular legal source, and this I call accumulation. By stratification, I mean the increase in different types of sources, so the layering of sources, the addition of sources upon one another. So if we conceive of Islamic law as starting with the Quran, stratification process would continue with the addition of the statements of the Prophet, and then the statements of the caliphs who follow the Prophet, and then the companions, the followers, as well as the decisions and statements of bureaucrats of various levels, such as governors, judges, and the anonymous traditions, legal traditions that arise from a variety of these factors. So this is the process of the stratification of sources. Contraction in the second period refers to the process by which a jurist decides which evidence to rely upon and which evidence to discard within a particular legal source. So that's the counterpart of accumulation. And by elimination, I mean the total rejection of the binding authority of a particular legal source. So I suggest that Islamic law can be divided, the development of Islamic law can be divided into two periods. The first period is the accumulation of legal content and stratification of legal sources, and the second period is contraction of legal content and elimination of legal sources. And the important period of transition is not with Shafi'i, but rather before Shafi'i with Abu Hanifa and his students, Abu Yusuf and Muhammad ibn Ḥassan al-Shaybani. So the important question is, how is it that Abu Hanifa and his students in Kufa played such an important role in this development? I think part of the answer has to do with the fact that Abu Hanifa and his students were the inheritors of the Kufan legal tradition. The Kufan legal tradition was distinctive from the legal traditions of other cities, such as Damascus and Medina, in a very important respect, which is that Kufan scholars from the very beginning of the Umayyad rule seem to have rejected the legal authority of the Umayyads. There are several reasons for this. One obvious reason is Kufa was the capital of Ali, and the scholars of that city were very much loyal to Ali and his family, whom the Umayyads saw as their chief political rivals. So this already created a certain antagonism between the scholars of Kufa and the Umayyads. Another reason was the heavy-handed rule of Hajjaj, who was Abdul Malik's governor of Iraq. Hajjaj was a very devoted follower of the Umayyads. He wanted to ensure the preservation of Umayyad rule by any means possible. He considered rebellion against the Umayyad Caliphate as apostasy, and therefore was very heavy-handed in the suppression of any sort of opposition to the Umayyads. At the same time, Hajjaj was the governor of Iraq, a very different sort of figure. Umar ibn Abdul Aziz was the governor of Medina. While Hajjaj imprisoned, forced into hiding, and executed the leading scholars of Kufa, Umar ibn Abdul Aziz very much honored and consulted the leading scholars of Medina. So Kufa and Medina, at the early stage of the Umayyad dynasty, had very different, shall we say, experiences with the Umayyad dynasty. So we can see that whereas among Kufan scholars there is this pronounced opposition to the Umayyad dynasty and their legal authority, the scholars of Medina very much continue to rely on the decisions of the state and its administrators, like all Muslims had done in the period of the rightly guided caliphs. So as a result of these factors, we can say that the process of contraction and elimination already started earlier in Kufa than in other cities, and Abu Hanifa inherited this rejection of the Umayyad legal authority. So what is Abu Hanifa's own contribution to this in this development? Well, I think Abu Hanife's own contribution comes out when we compare him with his primary teacher from the previous generation and the leading scholar of Kufa in the previous generation, Hammad ibn Abi Sulaiman. Hammad ibn Abi Sulaiman was a very devoted follower and a follower of Ibrahim an-Nakhai, his own primary teacher in Kufa, and he was very devoted to his legal opinions, which shows his acceptance of the legal authority of the statements of the followers. At the same time, Hammad was very dismissive of the legal traditions of other cities. That is to say, he really considered Kufan legal tradition to be the supreme interpretation of Islamic law. And interestingly, once Umar ibn Abdulaziz, after he becomes the governor of Medina and is afterwards dismissed, once he becomes the caliph of the Umayyad dynasty, the early Hanafi sources have preserved a report in which Hammad ibn Abi Sulaiman asks Umar ibn Abdulaziz for a fatwa, which I think is very significant because it suggests that the Kufan legal scholars did not reject the legal decisions of the caliphs primarily because they were caliphs, but rather because they did not consider them to be righteous caliphs. And once there was a figure such as Umar bin Abdulaziz, whom a lot of the ulama considered as a righteous caliph, as a righteous ruler, we see that Hammad ibn Abi Sulaiman, who has very negative comments about Umayyads and their followers, does not hesitate to ask Umar ibn Abdulaziz for legal opinion. So it suggests that the rejection of the Kufan scholars, their rejection of the legal authority of the Umayyads was not so much epistemological, but rather political. Once the political obstacle was overcome by a righteous ruler, Hammad ibn Abi Sulaiman, like other scholars from the followers, very much valued the decision of the caliph, the legal opinions of the caliph. So if we take these 3 points and compare Abu Hanife's approach to these 3 issues, the very striking development as regards the elimination of sources comes out. Abu Hanife and his students, unlike Hammad, theoretically and explicitly state that the legal statements of the followers do not constitute binding legal evidence. They both state this at the theoretical level and systematically applied this principle in legal issues, and on many issues they, unlike Hammad, reject the legal opinions of Ibrahim an-Nakhai, who was the leading jurist in Kufa and one of the most influential legal thinkers in the whole of Islamic history. So they repeatedly reject the legal opinions of Ibrahim an-Nakhai, either because of other evidence, other transmitted evidence, or because it does not agree with their legal thinking. So this shows their elimination of the legal authority of the follower statements. As regards the authority of the local legal tradition of Kufa, unlike Hammad, Abu Hanife and his students are not dismissive of the legal traditions of other cities. In fact, there are reports transmitted in both Hanafi and non-Hanafi sources that Abu Hanife considered Ata ibn Abi Rabah, Ibn Abbas' student, as a more distinguished legal thinker than his own Kufan teacher Hammad, and there are instances in which Abu Hanifa and his students prefer reports transmitted in other cities such as Mecca, Basra, or Medina to the legal opinions and legal evidence transmitted in Kufa. So this shows their rejection of the binding authority of local legal tradition. As regards Umar ibn Abdulaziz, it is quite interesting that on multiple occasions Abu Hanife and his students explicitly reject the legal opinions of Umar ibn Abdulaziz. Now, I don't think this is because they had a different opinion of Hammad. I don't think this is because they did not see Umar ibn Abdulaziz as a righteous ruler, but rather they very much had this epistemological understanding that no one possessed binding legal authority after the companions. No single individual possessed binding legal authority after the companions. So they reject the legal opinions of Umar ibn Abdulaziz, either again because it does not agree with other transmitted evidence that they consider stronger, or because it doesn't agree with their own legal thinking. So this shows that their rejection of the legal authority, the binding legal authority of the legal decisions of the caliph, and this rejection, I think, is for the first time not political but rather epistemological. So this is the process of elimination in the legal thought of Abu Hanifa. As regards contraction, Abu Hanifa developed this intricate legal epistemology based on a hierarchy of certainty. And the very foundation of his legal methodology was the understanding that less certain evidence could not modify more certain evidence. So he considered legal statements to be in multiple levels. The highest level was occupied by the Quran and famous or widely known hadiths that were transmitted by the jurists of more than one city. And at a lower level were the statements of the Prophet that were not transmitted by multiple cities but were transmitted by single individuals, the category known as Khabar al-Wahid. And at another level, there were the statements of the companions. So Abu Hanifa and his students considered that as long as there was a clear statement at a higher level, no statement from a lower level could modify or change that statement. But if there was any ambiguity at a higher level or any tension between a literal reading of two statements from a higher level, Abu Hanifa went down to a lower level and took advantage of any information available there. So if there was a clear statement from the Quran and there were the reports attributed to the Prophet that were transmitted by single individuals, Abu Hanifa did not allow these reports to change his literal understanding of the Quran. But if there was any ambiguity in the literal reading of a particular ayah or a tension between literal reading of two ayahs, Abu Hanifa went down to a lower level to take advantage of any information available there from reports that were less certain. And if there were likewise any ambiguity in the statements of the Prophet or tension between a literal understanding of two statements from the Prophet, Abu Hanifa went down to a lower level, the statements of the companions, to choose between these two statements or to resolve the ambiguity. So this hierarchical classification of knowledge led to the rejection of many reports that were accepted by other jurists in other cities. So this was a process of contraction in the legal thought of Abu Hanifa. So what is the end result? The end result is that we see in the first period of the accumulation of legal content and the stratification of legal sources, in the first period, the definition of the word Sunnah slowly, gradually increases. So it includes the statements of the Prophet, statements of the companions. In the legal methodology of Medinan jurists, such as Sayyid ibn al-Musayyib and Malik ibn Anas, it also includes the anonymous local legal tradition of Medina. In the methodology of a distinguished Syrian scholar such as Awza'i, it includes the legal decisions of the Umayyad caliphs. We see that with Abu Hanifa and his students, this definition is narrowed down and only includes the statements of the Prophet and the companions. So if we move to Shafi'i, what is his contribution and how is he different from Abu Hanifa and his students? Well, as regards the elimination of sources, we see in fact that he relies on the same transmitted sources as do Abu Hanifa and his students, and this is interesting because in the beginning, while he's a student of Malik, just like Malik and other scholars of Medina, and in fact Muslims elsewhere, he regards, according to his own words, the anonymous local legal tradition of Medina as binding legal authority, for which he abandons his own independent juristic reasoning. But once he moves to Iraq and closely studies the works of Abu Yusuf and Muhammad ibn Ḥassan al-Shaybani, he realizes that their rejection of the anonymous local tradition of Medina is valid, and he accepts this part of their legal methodology. So in fact, this rejection of local legal tradition is not something that Shah learns from the traditionists and teaches to the jurists, but rather it is something he learns from the jurists and teaches to the traditionists. As regards contraction, there Shafi develops or advocates a very different methodology, whereas Abu Hanife's methodology, as I've just mentioned, is based on vigorous content criticism. Shafi's legal methodology, as regards contraction, is very much based on rigorous transmission criticism. That is to say, he evaluates reports according to the reliability of their transmitters and the continuity of transmission. And in fact, this method of contraction or selection becomes the dominant methodology among hadith transmitters later on. As regards the concept of Sunnah, we see that the larger concept of Sunnah, which narrows down to the statements of the companions and the statements of the Prophet with Abu Hanifa and students, with Shafi narrows down further to only include the statements of the Prophet. But does this mean that Shafi rejected the legal authority of the companion statements? Well, the traditional answer in both classical works of Shafi and Hanafi legal jurisprudence is that yes, Shafi did reject, was in fact the first person to reject the legal authority of companion statements. This is the opinion of the classical sources. But there have been scholars both in the medieval and modern periods who rejected this interpretation. Among them are Ibn Qayyim al-Jawziyah, the famous student of Ibn Taymiyyah. He states that he read all of Shafi's works and did not find anywhere a statement in which he rejects the legal opinions of the companions, and explicitly states that the attribution of this methodology to Shafi is a misattribution. In the modern period, another famous and distinguished legal historian, Abu Zehra from Egypt, states both in his work Shafi and Usul al-Fiqh that in fact Shafi very much relied on the statements of the companions as a legal source. So having read these, their criticism of this, the attribution of the classical works, I was very much interested in looking in Shafi's own works and the works of his immediate students to see which claim was correct. And it became clear to me that Ibn Qayyim al-Jawziyah and Abu Zehra were correct, and that Shafi very much advocated relying on companion statements at a theoretical level and applied this methodology in practice in legal issues. So the Shafi's approach to companion statements was not one of elimination, but rather one of contraction. He rejected companion statements only when they seemed to contradict statements from the Prophet. But where there were no statements from the Prophet, Shafi very much relied on the statements of the companions, both at the theoretical and practical level. So the next question becomes, who was the first, if it's not Shafi, who's the first jurist to reject the legal opinions of the companions, and how did this process take place or spread to other legal schools? According to my research, the earliest jurists to in fact completely reject the legal authority of companions is Dawood al-Zahiri, the founder of the Zahiri school. After Dawood al-Zahiri, we see this rejection of this legal authority of companion statements in other schools. For example, in the Hanafi school, it starts with Karhi, who argues that the statements of the companions can only be accepted in issues in which there is no room for analogy. So in these issues where there is no room for an analogy, the statements of the companions should be accepted, but where there is room for analogy within a certain legal issue, Karhi says that he does not accept the statements of the companions and that the legal reasoning of the jurist is preferable. In the Maliki school, the famous Ash'ari theologian Baqilani is the first to reject completely the legal authority of the companions. He thinks that the companions were, as humans, were capable of error, and so he thought that since they were capable of error, their statements had no distinction from the legal reasoning of any other jurist at any other time, who was also capable of error. So he thought that the statements of the independent juristic reasoning of the jurist was preferable to the legal statements of the companions. In the Shafi'i school, there's a gradual process of the rejection of the legal authority of companion statements. Abu Ishaq Shirazi argues that the statements of the companions can only be accepted if they are famous, they're widely known, and no opposition to that statement is known from any other companions. In such situations, Shirazi argues that this statement from the unopposed, widely known companion statement represents consensus and is a certain legal evidence that has to be followed. But when the evidence is not, when the statement is not famous, then Shirazi, like Baqillani, thinks that it does not constitute binding legal evidence. Juwayni, Imam al-Haramain Juwayni, the primary teacher of Ghazali, has a different take. His writings on the issue echo the statements of Karhi. He thinks that where there is no room for analogy on that particular legal issue, statements of the companions should be followed, but when there is room for legal thinking on that issue, the statements cannot be followed. Finally, Ghazali argues that the statements of the companions are not binding at all, and his position becomes the established Shafi'i doctrine. And this is interesting because he's written 3 famous works on Islamic jurisprudence. In the earliest work he wrote, which is basically a summary of the legal opinions of his teacher Juwayni, he repeats Juwayni's statement that they should be followed if there's no room for analogy, and they should not be followed when there is room for analogy. But in his mature and final work of legal methodology, in Al-Mustasfa, he completely rejects the legal authority of the companion statements, which I think is significant because with other scholars you see this process of contraction and elimination in the writings of different scholars. With Ghazali, you see this process of contraction and elimination in the earlier and later works of the same scholar. After the Shafis, the final school in which the statements, in which a scholar rejects the binding authority of the statements of the companions, is the Hanbali school in the person of Ibn Aqil. Ibn Aqil likewise thinks that the statements of the companions do not constitute binding legal authority. So with that, we have some scholars who rejected the statements of the companions in each Akshan Sunni school. So is it that these scholars were influenced by Dawood al-Zahiri, who was the first to reject the legal authority of the companions? I don't think so. I don't think this is because their rejection is either due to the fact that they were influenced or even read the works of Dawood al-Zahiri. I think the real reason for the spread of the rejection on companion statements in all of these different legal schools is that they lived in this period of contraction and elimination that was initiated by Abu Hanifa and his students. Before Abu Hanifa and his students, jurists discussed and debated particular legal opinions and particular legal positions. For the first time with Abu Hanifa and his students, it is not only particular legal statements or opinions that are discussed, but rather evidence is sought for whole legal sources that are used in justifying legal opinions. And once this switch takes place from legal thinking of the first degree to the legal thinking of the second degree, from a situation in which jurists discuss opinions to a situation in which jurists discuss the validity and the authority of legal sources, the rejection of certain older sources becomes inevitable. So I think this is the main reason for the rejection of the authority of companion statements is this process of contraction and elimination with Abu Hanifa and his students initiated. Thank you very much.
From our current life, is there any interpretation by the companions of the Prophet ﷺ that has been rejected, but that has drastic change, or that has drastic consequences for what we are living in our life right now as Muslims, or are we talking about just very minor detailed interpretations?
It's hard to give a blanket answer. I think one has to be more specific. I think
Is there any example, jurisdiction or fatwa by the companions that has been rejected and that has a drastic effect on how we interpret the law right now? Or are we talking about just like minor interpretations?
One example that comes to my mind is this issue of Muallafetul Qulub, one of the 8 classes of people who were able to receive the zakat in the time of the Prophet were the Muallafetul Qulub, who were either recent converts to Islam or people who were leaders in their communities, and so this financial means was used as a method of persuasion. In the caliphate of Abu Bakr and Umar together thought that this class of people should no longer be able to receive the zakat, right? Because Islamic State by that time was quite strong, and so there was no need to be able to persuade these people through financial means when the military power of the Muslim state was overwhelming. One of the issues is, should this class of people be eligible to receive a portion of the zakat or no? So if we look at the statements of the companions, most of the companions, or perhaps all of them, very much accept the position of Abu Bakr and Umar that these people were given financial, these people were given money to strengthen the Islamic State, and so once the Islamic State is strong, there is no need to give money to them again. But several centuries later, the Hanbalis, some Hanbali scholars, such as Ibn Qudameh al-Maqdisi, thought that this was unacceptable, that since this was the practice in the life of the Prophet, the later interpretation of the companions could not be accepted. And so jurists who thought this way consider that this 8th class should also be eligible to receive money from a portion of the zakat. Now, does this have any influence in our lives? Some of my teachers in Syria have told me that this debate did take place in Syria, when you have certain officials who inspect these religious institutions, the official religious institutions, should they be given a portion of the zakat so that they have a favorable view of that religious institution. And so some scholars have suggested that these officials or inspectors can be considered like the Muallifatul Qulub and can be given a portion of the zakat, whereas other scholars think that this is not acceptable, that the zakat should be only given to poor people and should not be given to this class of people following the legal understanding of the companions. So I think that I can't give a categorical answer. On some, I think there might be some important issues, and there might be some minor issues. So it depends on the particular case.
I'd like to follow up on the last question in the sense of the major and minor, because what I'm thinking, and maybe you can help me think it through, is that actually the major, I mean, aside from whatever might, as a particular issue, be major, isn't one of the implications of your work that the concept of Sunnah is shifting or being negotiable during these different strata of development? So there's a major implication in terms of actually what is Sunnah. Could you speak to that?
Sure. I think you're absolutely right that, for example, Abu Yusuf, in his refutation of the Siyar al-Awza'i, repeatedly criticizes and rejects the legal opinions of Awza'i and scholars of Medina, because they consider that the decisions of the Umayyad caliphs or the unanimous tradition of Medina reflect the Sunnah of the Prophet. And he says this cannot be taken for granted. So he rejects the basis of their argument because he considers that a claim that something is the Sunnah cannot be accepted without, verifiable evidence. So, and you see that this causes Abu Hanifa and his students to reject a number of legal opinions advocated by the statements of the legal opinions of the scholars of Medina and Syria. So I think you're right. It has significance.
Sorry, but then I went somewhere else, and it may be too far from your interest, but it occurred to me that it would then be interesting. I thought of Fazl Rahman, roughly contemporary modernist thinkers in the Islamic tradition, and their approach to Sunnah. And I also thought about, Ghair Muqallidun or Wahhabis, people who do not do taqlid. And it seems to me that each of those more, later groups, has sort of a place in your argument, or, this issue of what is Sunnah. Because the modernists such as Fazl Rahman would say, as I remember it, correct me, I could be getting it wrong, but would say, well, maybe Sunnah in the Islamic tradition is much broader than actually what the Prophet, peace be upon him, did. It was this whole practice of these communities. And of course, from the liberal modernist point of view, if you construct Sunnah as kind of what people were doing, it makes it easier to sort of say it's historically and humanly conditioned. Do you see what I mean? Like that's one way that you could sort of take that argument about how fixed is the Sunnah. And then I have not really figured out the Wahhabi piece, but in this, actually maybe it's too abstract, but in the sense that would somebody who rejects the authority of the legal schools, would that person want to keep the legal opinions of the companions, or would that person in fact also tend to reject the legal opinions of the companions and say, let's just only stick to the Quran and the ahadith that we all know come exactly from the Prophet, and everything else is, more suspect. So I'm not really sure about that, and I don't know if you've thought about it. But.
Well, yeah, I have thought about it. There is no necessary relationship between rejecting taqlid and rejecting the statements of the companions. And the reason I say that is, taqlid means following a certain legal opinion without knowing the reason for this, right? That's the definition of taqlid, or one of the definitions of taqlid. Well, for people who consider the statements of the companions as binding legal evidence, they're not doing taqlid when they follow the statements of the companions. Just like Muslims do not consider themselves as doing taqlid when they follow the statements of the Prophet, because they know why they follow the statements of the Prophet. For scholars who think that the statements of the companions do possess legal authority, when they base their statements on the legal statements of the companions, they're not doing taqlid. They're very much engaging in legal thinking. And the statements of the companion is original and binding legal evidence. You see what I'm saying? But for people who do not see companion statements as legal authority, as possessing legal authority, then following the legal opinions of the companions would be taqlid. You see what I'm saying? So whether following the statements of the companions is considered as taqlid or not is very much dependent on whether you see their statements as decisive legal evidence in the first place. Okay?
How about the modernists?
Well, my work was primarily a work of legal history, so I can only say what the jurists I've studied have said about legal opinions similar to those you expressed. Fazlur Rahman is an interesting case, I think, because on the one hand, he's very traditional in that he rejects very strongly Shah's idea that the Prophet was not regarded as a legal model by Muslims in the first century. So he very much rejects this explicitly in both his work, Islam and Islamic legal methodology. He explicitly rejects that view. On the other hand, he thinks that he thinks like Shaht that the hadiths we have today do not represent the statements of the Prophet, but primarily represent the legal opinions of the Muslim community as it developed. So his starting point is very different from Shaht, but his ending point is the same. Okay? So I don't think traditional jurisprudence of the legal schools I've studied would have accepted Fazlur Rahman's latter claim. I think they would say, they might say that there are instances in which this is the case, and that that there is a methodology to identify such cases, but we cannot assume that this has to be categorically accepted as the case, right? So they will not accept Fazlur Rahman's claim that is in agreement with Shah that one cannot identify reliable reports from the Prophet. So that's where they would have differed.
My question is, in your study of the legal history, Islamic legal history, how much room you see among the scholars' discussions and opinions for interpreting the Sunnah, whether it is the opinions of from the Prophet ﷺ or Khulafai Rashid or the other companions, but the time and space factor. In other words, many of these were specific to a certain situation at a certain time. How much room did you see that in application at a different time, in a different situation, that you could take the gist of it, the maqsad, and apply, instead of applying that ruling or opinion verbatim, applying it in the sense of what the intention was? How much room do you see in the discussion, or they have been very rigid? That question.
Yes, I think there's a clear distinction there between the older legal schools, that say the Hanafi and Maliki schools, and the latter legal schools, the Shafi and the Hanbali schools, in the sense that Hanafi and Maliki jurists in their definition of Sunnah, very much seek this quality of persistence and repetition. So what they regard as the Sunnah are those actions on which the Prophet and the companions persisted upon, right? For Shafi'is and for Shafi'is and Hanbalis, any statement from the Prophet, if it's sound, it's considered the Sunnah, right? So they do not seek this quality of persistence and repetition. Okay, so I think what, again, speaking as a student of history, I think how classical jurists would respond to your statement would be to say, especially Hanafi and Maliki jurists would say, well, if we see that the Prophet and his companions repeat a certain course of conduct over and over again, and there are multiple reports that transmit this situation, then we know that action or that conduct is not situation specific, but has more general application, right? But if it's a one-time action or a one-time statement that does not seem to be repeated, then they would not straight away say that that is the Sunnah. Okay, so I think Islamic legal thought is very diverse, and I think in both what I call the accumulation and stratification period of Islamic history and the contraction and elimination period, there was great legal diversity among the jurists of different cities and in the legal thinking of jurists from the same city. So my claim is not that you have this uniform process of accumulation and elimination and accumulation and stratification and a uniform process of contraction and elimination. There were exceptions in both periods, but I think that there is a general movement towards accumulation and stratification in the first period, and the general movement that is evident in the works of several jurists from different areas in the second period. Thank you.
We have time for just one last question.
So when we talk about the Sunnah, basically we are talking about the archive, which is what's the Prophet stated and its explanation to the Quran and the whole message. And we also talking about the view of the Sahaba, which is being with the Prophet at that time. So given the locality and given that Islam in the early life, in the 3 or 4 Caliphate, have 3 or 4 civil war, how much politician, what's the politics in that time? How did it affect the jurors or the justice system in the early Islamic life?
Well, as I mentioned in the beginning of my presentation, I think different understanding of the role of the state already caused bifurcation in legal methodology early on. That is to say, as I said, the jurists of Kufa had this antagonistic relationship with the Umayyad state and rejected the legal authority of the statements and the opinions of the Umayyad caliphs and their administrators, whereas jurists of other cities such as Medina and Damascus continued to rely on the decisions of the caliphs.
That was later on. I'm talking about the period between the Prophet and the last Khalifa. Because, there is 4 Khalifa, which we call them the Khalifa Rashidin. And after that, the Umayyad dynasty and the Abbasid dynasty. So when we talk about Abu Hanifa or Malik, that's later on. I'm talking about the period in that 4th Khalifa. Because we rely, most of our, jurists rely on that period, which is some people think there is a certain people which we can qualify them to be Sahaba. And there's a school like the Wahhabism, think anybody who saw the Prophet, they consider to be a Sahaba, and we can take whatever they said. I mean, assuming that whatever they said was going line with line with the message of the Prophet. So I'm talking about the period.
Okay, I understand now. You mean specifically in the period of the rightly guided caliphs, right? Okay, I think in the period of the rightly guided caliphs, the general tendency, the general movement in all Muslim cities is to accept the legal statements of the legal statements and legal decisions of the rightly guided caliphs. In fact, we see that what some later jurists have called consensus is frequently the legal decisions or the legal opinions of the rightly guided caliphs. So I think in that period, reliance on the decisions of the caliphs and their governors and judges is very common and commonly accepted, as opposed to a later period, as I stated and as you have observed in the Umayyad period, there is a bifurcation and diversity. As regards the other component of your question, this idea of who is a companion, I think that was something that was debated early on, that is anyone who has seen the Prophet a companion, or does it have to be someone who has spent an amount of time with the Prophet and knows him closely? So Islamic legal thought is very diverse, and there has been diverse answers to that question from an early period. Some scholars suggesting that only the companions who were very close to the Prophet have legal authority, and then a broader understanding in which anyone who has seen, or even has not seen because he is blind, anyone who has spent a particular time with the Prophet is considered a companion. So that's another issue in which there's diversity in legal thinking. Thanks.
Thank you very much.
Thank you.
Thanks. Now I would like to invite Dr. Marcia Hermanson, AMC board member and director of Islamic World Studies at Leo University, and to present a gift for Summa Cum Laude.
Thank you very much. Thank you.